I want to take just 2 minutes first to welcome our panelists, who I'll introduce in a moment. I also just want to summarize briefly yesterday's testimony. I think in the forefront of the minds of many regulators and prosecutors these days are the significant law enforcement challenges posed by virtual currency. As recently as this past Monday, we had serious criminal conduct come to light involving virtual currency as a vehicle for money laundering, drug trafficking, and other major felonies. Obviously, any attempt to regulate virtual currencies is going to have to deal with the dark side of virtual currency. Yesterday, we had a first panel that dealt extensively with all the wonderful potential benefits of virtual currencies. A second panel that dealt with some alternative currencies, as well as some of the troubling and tricky legal issues we face in trying to regulate. And then today we're kicking off with an outstanding law enforcement panel to talk maybe a little bit more about the dark side of virtual currency and how we can take that into account as we figure out how to best regulate. We have two very distinguished prosecutors with us today, both of whose offices have shown leadership in this emerging area of law enforcement and also just generally in the area of cybercrime. Cyrus R. Vance, Jr., the District Attorney for New York County, who has been doing a fantastic job, and Richard B. Zabel, the Deputy United States Attorney for the Southern District of New York. I'm happy to say not only are they the best and the brightest around, but also, I think I can say this, I'm happy to call them both friends. So thank you both for being here, and very much look forward to your testimony. As a formality, I have to swear you in, so if you'll each rise and raise your right hand. Do you swear or affirm to tell the whole truth, the whole truth, and nothing but the truth, so help you God? Thank you. So we're going to turn first to District Attorney Vance, and thank you again for being here. We really look forward to your testimony. You need to have the green light on, or they will yell at you.
Thank you. Superintendent, good morning. Members of the panel, good morning. It's a privilege to be able to be here to speak briefly about the issues that you have raised in these important hearings that seeks to understand the implications of that surround digital or virtual currencies. To follow the superintendent's initial comments about the world changing, I think we've all thought growing up that a crime scene was typically defined by yellow police tape on a corner where someone had committed an offense. But the reality of today is that the Internet is our 21st century crime scene. And our society, our regulators, our prosecutors, all of us have to adapt to that new reality. And as we all know, the Internet provides criminals, cyber criminals, with anonymity, or at least certainly makes that much easier, and that makes the task of investigating and prosecuting crime that is committed using cyber techniques all the more difficult. And in our opinion, exploiting digital or virtual currency payment systems really is no different. The anonymity offered by these payment systems attracts, from time to time, criminals who now can more easily move, conceal, and launder illicit profits. Our office has prosecuted a number of cases in this area, which I'll discuss in a minute. But what I want to say just at the beginning is I believe and respectfully suggest that as you analyze this area involving digital and virtual currency, that you keep in mind the question of what tools prosecutors, whose job it is to protect the public, will need in order to do their job and do their job as it relates to illegal conduct that stems from these payment systems. Without stronger government oversight in this area, I believe we are going to be permitting cyber criminals, identity thieves, even traffickers of child pornography, and other criminal actors to operate in what will be a digital Wild West. And it's our position, respectfully, that digital currency exchanges should be required to obtain licenses as money transmitters in order to do business in New York State, and therefore come under that regulatory framework. Our belief also is that action may not in and of itself be enough, depending upon the regulatory framework that you decide to use, if any, in going forward. We believe that there should be an examination of whether to require digital currency exchanges to perform enhanced due diligence with regard to the identification of their customers. So let me give you two quick, concrete cases that relate to criminal activity facilitated by digital currency. Last year, our office secured convictions of 14 members of an international major cybercrime ring that crisscrossed the globe, from Russia, Ukraine, and Moldova to the Czech Republic, to California, to Brooklyn and Manhattan. And the ring, in the time of its criminal activity, trafficked in more than 100,000 stolen credit card numbers and identities, resulting in millions of credit card fraud, as well as dislocation, disruption, fear, concern from those who were victimized by this conduct. And one of the top defendants in that case was recently sentenced to 22 to 44 years in prison, which I think gives you an indication of how seriously state judges, let alone prosecutors, are now viewing this conduct and the impact that it can have on members of our communities. At the center of this organization was a corporation based in Manhattan called Western Express. The company served as the principal digital currency exchanger for this trafficking ring, allowing buyers and sellers of stolen credit card information to move money anonymously, in that case using two types of digital currencies, e-gold and web money. And this is how the trafficking operation worked. Essentially, the Western Express acted as a money exchanger, but in this manner. The buyers of stolen credit card information used Western Express to exchange U.S. currency in the form of cash or money orders or other structured payments into e-gold or web money. The buyers then took this virtual currency and used it to buy stolen credit card information and identities from the vendors being the criminals who had stolen it. They used this stolen information to manufacture forged credit cards, which they then used to purchase merchandise online and in stores, and then fence those products or online or on the street for profit. The vendors needed to convert all the e-gold and web money they received as payment for stolen data into either a different digital currency or into conventional money, and they used Western Express also for that purpose. Western Express also in this enterprise facilitated the global flow of digital currency for criminal activity in the tune of many, many, many millions of dollars and sent bank wires all around the world. Western Express charged a fee for every transaction that it facilitated. A second case relates to a different company called Goldage, a digital currency exchanger operated by two men who moved millions of dollars around the globe for their customers. In that case, individuals used Goldage to exchange e-gold digital currency. And when they purchased e-gold, the customers could choose their method of payments to Goldage. They could wire money, make cash deposits, or mail postal money orders or checks. And when they sold e-gold to Goldage, customers could obtain payments through wire transfers to accounts anywhere in the world or have checks sent to individuals anywhere in the world. Goldage's owners charged customers a fee on both ends of the transactions and maintained various bank accounts under the guise of different subsidiary companies. Now, in both of these cases, the fact that the defendants ultimately converted digital currency back into cash helped investigators to trace the money. But now that retailers, both large and small, are starting to accept digital currency as payment, criminals may not have to convert their illegal proceeds back into cash at all. For example, criminals can use digital currency to buy high-end merchandise from major online retailers and then sell those products for cash, or they can simply refrain from ever converting their digital currency to cash, simply continuing to use financial criminal conduct to finance their criminal conduct and engage in business, whether criminal or legitimate, using the currency. This makes it even more difficult for law enforcement to trace these transactions. Another possible challenge to law enforcement may be the emergence of Bitcoin ATMs, in which individuals can insert dollars and get Bitcoins in return, but unlike users of debit or credit cards, the identification of Bitcoin ATM users can remain untraceable. I want to note, Superintendent, that I'm not taking a position at all on the legitimacy of digital currency as a method of payment for goods and services. And I recognize that many digital currencies are certainly not designed to facilitate criminal conduct. But we live in a world in which criminals are exploiting new manners to commit crimes every day. And this is an area where individuals are now seeing seams, weaknesses, where they can move into and exploit and victimize members of the public. Digital currency is quickly becoming part of our mainstream economy, and along with the mainstream, it brings behind it, and in that slipstream, criminals who will exploit these gaps in our regulatory and criminal justice system. I believe, therefore, that law enforcement should be, assuming that you move in a regulatory manner, we need to be given appropriate updated tools to address, investigate, and convict criminals who are engaged in misconduct in this area. Under our current law today, money transmitters must comply with anti-money laundering requirements. Financial institutions facilitating deposits and withdrawals of large amounts of cash must file currency transaction reports with FinCEN. Cross-border movements of large amounts of cash also require governmental reporting. These valuable filings allow law enforcement to identify and investigate potential criminal activity. I don't believe, respectfully, there should be ambiguity that virtual currency exchanges that transmit value act as money transmitters and are therefore required to comply with the same licensing, reporting, and anti-money laundering regulations imposed on banks and other money exchangers. And that's consistent with numerous prior prosecutions conducted by my office. And there's no question that digital currency providers act as a medium of exchange in the sale and purchase of goods and services. Therefore, it is our opinion, in my opinion, that the nature of a transaction in which digital currency is purchased is indeed a form of money transmission, no different than where a buyer directs a bank to send money to a vendor. Furthermore, digital currency exchanges, we believe, should be required to perform enhanced due diligence with respect to their customers' identification in the event that the agency decides to promulgate new regulations. And so, in summary, in this area, we believe that digital currency exchangers, at a minimum, should be required to maintain records relating to transactions, obtain customers' identifying information, and that, we believe, should include requiring a customer to provide his real name, his physical address, the name of his business, and the nature of that business. And the customer should also be required to confirm that the digital wallet in which the currency is being sent is actually owned and controlled by the customer. Implement procedures to ensure the accuracy of this information. For example, that the address is actually owned and controlled by the customer. That would help with the chain of custody in establishing who is receiving the digital currency. And finally, to file periodic applications in order to do business. These filings should identify, in our opinion, the owners and managers of the exchange, and those principals should, we believe, make sworn affirmations as to the accuracy and truth of those filings. As we've seen in so many cases, digital currency is being used by bad actors, in serious criminal activities, multi-million identity theft cases, child pornography, and an underground market for drugs, guns, and other contraband. Mr. Zabel, on the federal side, the federal government is starting to bring digital currency exchanges under their regulatory umbrella, and we believe that New York State should also recognize the potential danger of these payment systems. We hope that your move will ultimately be to license the digital currency exchanges as money transmitters in order to do business in our state. And we believe they also need to adequately supervise the exchanges to ensure that their customers are providing proper identification and are not using exchanges for criminal activities. And we believe we must also act to ensure that unlicensed digital currency exchangers are identified and where they're engaged in criminal misconduct be prosecuted. Thank you for letting me give these thoughts, and I really am grateful for the opportunity to appear before you.
Thank you, D.A. Vance, for that very interesting and helpful testimony. I want to turn it over to Richard Zabel, the Deputy U.S. Attorney in the Southern District. I'll just add for his introduction, a lot of times the U.S. Attorney gets all the credit for many good things that happen in their office, and the Southern District is a well-known office with a lot of great things happening recently and over the last few years. And that's as it should be, but sometimes there are people who work right behind that U.S. attorney who are key to their success, and Mr. Zabel is one of those people in the Southern District, and I've been a big admirer of yours for a long time. So welcome. We look forward to your testimony.
Thank you very much. Thank you for those kind words. Mr. Superintendent and distinguished members of the New York State Department of Financial Services, thank you for the opportunity to appear before you today to discuss the law enforcement work of the United States Attorney's Office for the Southern District of New York and our federal agency partners in combating criminals and criminal enterprises that use virtual currencies to carry out their illegal activities. I am honored to represent the U.S. Attorney's Office at this hearing and to describe to you our approach to virtual currencies, some of our recent criminal cases in this emerging area, and some of the issues that we have observed and that concern us going forward. First, in our approach to virtual currencies, we recognize, first of all, that virtual currency systems can be legitimate, innovative, global commerce mechanisms that may offer advantages over other forms of payment. Some advantages can be efficiency, cost benefits, and certain desired privacy features. Because we are not regulators, we do not focus on how to regulate and improve these emerging systems. Our concern is when the features of virtual currencies are exploited by criminals to carry out illegal conduct because the perpetrators feel they can more easily conceal their activity, their identities, and their proceeds. In attacking the criminal exploitation of virtual currencies, as in other areas of criminal law, we want to prosecute criminal conduct and maximize deterrence. To do so, we look to prosecute significant cases against individuals who are using or enabling others to use virtual currencies for criminal purposes. And where appropriate, we prosecute and shut down their illegal companies or websites as well. Our approach, therefore, has been to look at the virtual currency criminal ecosystem and identify significant individuals and entities who enable that illegal ecosystem. In many ways, as with other traditional cases, we are following the money, but here it is the virtual money. Our attack on criminal virtual currency schemes accelerated when our office ramped up its focus on cybercrime generally. At the beginning of his tenure in the summer of 2009, the U.S. Attorney, Preet Bharara, made combating cybercrime a priority of the office. We created the Complex Frauds Unit, and we embedded in that unit an expanded team of cyber prosecutors who focus almost exclusively on cybercrime, including virtual currencies. We've been fortunate that our great partners at Maine Justice, the FBI, Secret Service, DEA, IRS, HSI, and other agencies have also made this effort a priority, as has District Attorney Cyrus Vance. And since many of these cases extend internationally, it has been important that we and our federal partners have developed relationships in the cybercrime area with prosecutors and law enforcement all around the world. That has been our approach, and it has led to a number of significant prosecutions. So let me briefly discuss three of our recent cases because they illustrate some of the problems we have identified at different levels of the criminal virtual currency ecosystem. All of these cases are pending, so I will restrict myself to the public allegations as they are set forth in the charging documents and other public information. Of course, all the defendants, unless they have pled guilty, are innocent until proven guilty. So the first case is Liberty Reserve. As we have alleged, Liberty Reserve was in many ways the premier banking institution for cyber criminals. It operated its own centralized digital currency, commonly referred to as LR. The company billed itself as the Internet's largest payment processor and money transfer system, serving millions of people around the world, including the United States. It processed over 55 million illegal transactions and laundered more than $6 billion in suspected proceeds of crimes, including credit card fraud, identity theft, investment fraud, computer hacking, child pornography, and narcotics trafficking. Liberty Reserve was deliberately designed and operated to enable criminal users to conduct financial transactions anonymously. Liberty Reserve was used extensively for illegal purposes, functioning as the bank of choice for the criminal underworld because it provided an infrastructure that enabled cyber criminals around the world to conduct anonymous and untraceable financial transactions. Liberty Reserve never registered with the U.S. Department of the Treasury as a money transmitting business, as it was required to do under U.S. law. In order to use LR currency, a Liberty Reserve user first had to open an account through Liberty Reserve through its website and provide basic identifying information. However, Liberty Reserve did not require users to validate their identities, and users routinely established accounts under false names. In fact, a federal agent in our investigation was able to set up an undercover account in the name Joe Bogus with an address of 123 Fake Main Street in a city named Completely Made Up City, New York. Once an account was established, the user could conduct transactions with other Liberty Reserve users. In these transactions, the user could receive transfers of LR from other users' accounts and transfer LR from his or her own account to other users, including any merchants that accepted LR as payment. Liberty Reserve charged a fee for each transaction that was calculated as a percentage of the transaction value. And for an additional privacy fee, a user could hide his or her own Liberty Reserve account number when transferring funds, effectively making the transfer completely untraceable. Liberty Reserve did not permit users to fund their accounts by transferring money to the company directly through a credit card transfer or other means. Users also could not withdraw funds from their accounts directly. Instead, Liberty Reserve users were required to make any deposits or withdrawals through the use of third-party exchangers. In effect, this arrangement enabled the company to avoid collecting any information about its users through banking transactions or other activity that would normally leave a centralized financial paper trail. The exchangers did not provide a reliable means of tracing financial activity, as they tended to be unlicensed money transmitting businesses operating in countries without significant governmental money laundering oversight or regulation, such as in Malaysia, Russia, Nigeria, and Vietnam. By failing to collect identifying information about its users through its website and avoiding any contact with its users through the traditional banking system, Liberty Reserve intentionally provided its users with nearly impenetrable anonymity and enabled them to conduct untraceable financial transactions. Liberty Reserve and several of its principals and employees were charged with conspiracy to commit money laundering, conspiracy to operate an unlicensed money transmitting business, and operation of an unlicensed money transmitting business. Let me turn to the second case called Silk Road. As alleged, Silk Road was an underground website that emerged as the most sophisticated and extensive criminal marketplace on the internet. Silk Road served as a sprawling black market bazaar where unlawful goods and services, primarily illegal drugs of almost every variety, were bought and sold regularly by the site's users. The volume of illegal transactions conducted on Silk Road was staggering. During its approximately 2.5 years in operation, Silk Road was used by several thousand drug dealers and other unlawful vendors to distribute hundreds of kilograms of illegal drugs and other unlawful goods and services to well over 100,000 buyers, and to launder hundreds of millions of dollars derived from these unlawful transactions. All told, the site generated sales revenue of more than 9.5 million bitcoins and collected commissions from these sales totaling more than 600,000 bitcoins. Silk Road was designed to enable its users to buy and sell drugs and other illegal goods and services anonymously and beyond the reach of law enforcement. That was achieved in two principal ways. First, Silk Road was operated on the Tor network, a special network of computers on the internet designed to conceal the true IP addresses and therefore the identities of the network's users. Second, the method of payment was deliberately restricted to preserve the user's anonymity. Transactions on Silk Road could be paid for only with bitcoins, a decentralized virtual currency. Silk Road's payment system essentially consisted of an internal Bitcoin bank, where every Silk Road user had to hold an account in order to conduct transactions on the site. Every Silk Road user had at least one Silk Road Bitcoin address associated with the user's Silk Road account. These addresses were stored on wallets maintained on servers controlled by Silk Road. In order to make a purchase on Silk Road, a user had to obtain bitcoins, typically through a Bitcoin exchanger, and then send those bitcoins to a Bitcoin address associated with his or her Silk Road account. Once a user's account was funded in this way, the user was free to make purchases on Silk Road. Silk Road also used a so-called tumbler, which, as the site explained, sent all payments through a complex semi-random series of dummy transactions, making it nearly impossible to link your payment with any coins leaving the site. The tumbler, in our view, was essentially an institutionalized and automatic form of money laundering. Silk Road's alleged creator and owner, Ross Ulbricht, was charged with narcotics conspiracy, conspiracy to commit computer hacking, and money laundering conspiracy. Let me turn to our third and most recent case. Just 2 days ago, our office brought forth charges in another Bitcoin matter. As alleged, Robert Fiala, using the name BTC King, operated a Bitcoin exchange service directly on Silk Road that enabled Silk Road users to convert cash into Bitcoins anonymously. Fiala's customers could then use those Bitcoins to make illegal purchases on Silk Road. Fiala never registered as a money transmitting business, and he conducted transactions in a manner designed to enable Silk Road users to maintain their anonymity. To accomplish that, Fiala filled the orders for Bitcoins that he received from his Silk Road customers with the assistance of Charles Shrem, the CEO of a New York City-based Bitcoin exchange company. Shrem's company was designed to enable customers to exchange cash for Bitcoins anonymously, that is, without providing any personal identifying information. For example, to fund the purchase of Bitcoins, customers were instructed to deposit in person specific amounts of cash into bank accounts controlled by a third-party cash processor. Customers did not have to provide any identifying information other than an email address. After obtaining Bitcoins for his customers with Shrem's assistance, Fiala then sold the Bitcoins to Silk Road users at a markup. Shrem's company was registered as a money transmitting business and had certain anti-money laundering policies, which Shrem was responsible for enforcing as the company's compliance officer. However, instead of enforcing those policies, Shrem deliberately advised Fiala how to circumvent them so that Fiala could continue doing business with the company, thereby generating significant revenue in transaction fees for Shrem's company. Shrem was aware that Silk Road was a drug trafficking website and that Fiala was running a Bitcoin exchange service on Silk Road, but he still helped Fiala conduct his operation. Shrem never filed a single suspicious activity report, despite many obvious red flags. In total, Fiala and Shrem converted more than $1 million of cash into Bitcoin for Silk Road users, so that those users could make unlawful purchases on Silk Road. Fiala and Shrem were each charged with conspiracy to commit money laundering and operating an unlicensed money transmitting business. Shrem was also charged with willful failure to file a suspicious activity report. Now, these cases illustrate a number of concerns with virtual currencies, including Bitcoins, as their use increases. One concern is the combination of Bitcoin's anonymity and its ease of movement. Both characteristics offer advantages, but also can make it a magnet for criminality. The ease with which large amounts of Bitcoins can be moved anonymously without any geographic limitation makes the currency particularly attractive to those conducting illegal activity. Although cash is also an anonymous form of currency, there are significant practical barriers to transferring bulk cash outside of the traditional banking system. Generally, to make such transfers, the bulk cash must be physically transported or smuggled from one place to another. By contrast, large amounts of Bitcoins can be transferred anonymously and safely to someone located anywhere in the world with just the click of a computer key. A second concern is that virtual currency expands the geographic footprint of criminal activity and at the same time invites more criminal participants. For purchasers of drugs or other illegal goods or services, virtual currency reduces or even eliminates practical barriers to entry. On Silk Road, for example, users were able to purchase drugs from drug dealers located anywhere in the world, essentially with the push of a button. With traditional forms of currency, these purchasers would have had to hand-deliver cash to drug dealers. Similarly, the anonymous and largely untraceable nature of Bitcoins also makes it attractive to sellers of unlawful goods. In addition to the thousands of drug dealers who operated on Silk Road, we found that the merchants who accepted Liberty Reserve currency were overwhelmingly criminal in nature. Third, because the transactions not only are anonymous but are irreversible, virtual currency also appeals to those operating fraudulent schemes. In frauds such as advanced fee schemes, the fraudsters often previously relied on traditional money transfer services to collect money from victims because they perceived those services as offering greater anonymity than the traditional banking system. Now, we have observed that these fraudsters are seeking to take advantage of virtual currency because of the even greater degree of anonymity it offers. The Liberty Reserve vendors, for example, included peddlers of various types of online Ponzi and fraudulent get-rich-quick schemes. Fourth, virtual currency also facilitates the laundering of criminal proceeds, as it enables criminals to securely and anonymously distribute the proceeds of criminal activity to co-conspirators and others located anywhere in the world. A fifth concern is that the anonymous and untraceable nature of virtual currency also has tax implications, especially as the currency becomes more widely accepted. In terms of tax evasion, putting money into virtual currency may in fact be a way to conceal it from the taxing authorities. The currency itself then could effectively become a form of tax haven for both businesses and individuals. Sixth, as bitcoins become more prevalent, they will potentially create opportunities for investments based on their own intrinsic value. For example, people may invest in currency futures contracts tied to bitcoins or in Bitcoin mining companies, hoping for a return based on the amount of bitcoins mined. Such an investment market, based on a currency that is volatile and more lightly regulated, could lead to fraud based on manipulation and other analogs to securities fraud. In conclusion, virtual currencies like bitcoins are innovative and dynamic new systems that may offer many benefits. These currencies present complex challenges to law enforcement in terms of identifying and locating criminals who corruptly exploit them. We have had some success, as had the DA's office. But it is difficult work in part because of the layers of anonymity and geographical distance that our investigations have to overcome. But for all those who not only believe in the rule of law, but also hope for these currencies to take root and thrive, they should support law enforcement's efforts to ensure that individuals who exploit virtual currencies for criminal purposes are held responsible. Whatever the regulators and others determine should be the role of virtual currencies, the prospects for these new currencies are severely damaged if they become the currencies of choice for criminals. We look forward to continuing our work with all our federal, state, and international partners to protect the people from criminal conduct, whatever the currency. Thank you for inviting me here today. I'd be happy to answer any questions that you may have.
Thank you, Mr. Zabel, Yell at me, too. I thought I was on. Thank you, Mr. Zabel, for that very interesting testimony. I just have a few questions. Before I do that, let me just introduce the really smart people who are up here with me. To my right is Maria Filipakis. She runs our capital markets group. To my left is Daniel Alter, our general counsel at DFS. And to my far right is Dana Syracuse, who's a deputy general counsel at DFS. I'd like to start with a general question. It's something we've been struggling with getting our hands around, which is when it comes to virtual currency, as prosecutors, would you each say that there is, well, we're trying to decide whether there is something qualitatively different about virtual currencies as opposed to criminals who will use a prepaid burner cell phone, which cloaks their anonymity in one way, or terrorists who might use special encryption on computers to communicate and thus cloak their identities. Is there something qualitatively different about virtual currencies that concern you, or is this just another example of using the latest technology to become more or to try and enhance anonymity in order to commit crimes? And that's something we need to decide, I think, as a regulator, whether we need to do something entirely different or whether this is just the usual prosecutors will catch up with the latest uses by criminal elements of a new technology. So I don't know if you have a reaction to that, either of you.
I think there is a qualitative difference, and that is that we have seen the digital currencies becoming part of the potential mainstream market, a currency market and financial transactions market. And that means that if people misuse this medium for criminal purposes, if there is not adequate regulation of this medium in order to let regulators understand who are behind transactions and let prosecutors be able to follow those leads if there's an investigation, it is opening a big door into financial transactions around the world. They're both instances, whether it's a burner phone or encryption on a computer, are tactics that criminals may use in order to commit a crime. But I think the virtual currency becomes almost a strategic opening where you are really able to fuel and facilitate movement of money connected to crime in a qualitatively different way than simply masking communication from one criminal to another over a cell phone.
Zabel.
I would say that one of the aspirations for Bitcoin, and that's nascent at this stage, is for it to become a main artery of the commercial world. And in that sense, to the extent it wants to take a primary place, as opposed to things like burner phones and some of the other items that you discussed, which are prevalent but are not sort of central avenues of commerce, to the extent it wants to take that place, whatever characteristics it has that may lend itself to criminal activity more easily are more concerning and should be looked at more carefully, because burner phones, just using that example, I know you had others, but some of those things exist more at the periphery of the main commercial world. If Bitcoins are going to become a currency of the commercial world, then whatever weaknesses they may have to be exploited by criminals need to be addressed much more seriously, I think, than with other more peripheral items. So I think they're not, in some ways it's not that different than cash in many ways. But as I mentioned earlier, you can do things with it that you can't do easily with cash. So it lends itself to being exploited by people who mean harm much more easily. So it's perhaps some of its intrinsic qualities make it need to be treated differently, even though in essence it's trying to function in a way like cash and other things.
One of the issues that came up at some of the testimony yesterday was this question of, is there really anonymity with Bitcoin, at least with the virtual currencies that use what are called these public ledger systems, where, at least in theory, based on the software, I'm going to mangle the technical terms, but based on the way the algorithms are designed, every Bitcoin transaction should be traceable on this public ledger. And that was given, we heard that a lot, that you're not really anonymous when it comes to Bitcoin, you're pseudonymous. And I wanted to know whether either of you had a reaction to how hard that last hurdle is for law enforcement when, let's assume for the virtual currencies that have public ledger systems, that we can get to, that law enforcement can easily trace a transaction to particular computers. How hard is taking it to that next level and finding out the actual identity of the person involved in the transactions? I mean, I know it was something you faced, both of you faced in the cases you've brought recently. So,
well, I'm going to jump in and just say very briefly, having an IP address and knowing actually who's behind the IP address are two entirely different things.
right.
I may have an address. I may have someone may send a letter to a building as part of a criminal activity, but which of the 5,000 apartments in the building are we dealing with? So I think that's a sort of obvious, although I'm not technically a super technical guy, I think that's sort of an obvious difference.
I would say we've faced substantial hurdles in that. When we did the Silk Road case, there was a lot of speculation. How did we penetrate the Tor network to figure out where servers were located and who was doing what? I think that speculation continues, and I'll let it continue. But there were substantial challenges in that case because of that. So you have things like the Tor network. You have the tumbler that I mentioned. You have these tumblers that can be put in place, which in the cases I've seen, there may be out there legitimate uses for those that I'm not aware of, but in the cases I've seen, they serve no other purpose other than to be automated money laundering and identity concealers. So, and then remember, even if people are giving in names at some end of the chain in these transactions or email addresses or IP addresses, some of those are false. They don't necessarily resolve to any true person or way to identify someone. And you add to that they're spread out all over the world, which can limit you in a variety of other ways to make sure that you can really identify the person. It becomes very, very difficult for all those reasons, and there are others. So in a sense, as a theoretical matter, if we were in a laboratory, could you say that there's absolute anonymity? Maybe there'd be ways in a theoretical world where you could always ultimately, if you had unlimited resources, get to a person. But as you know very well, Mr. Losky, and as everyone on the panel knows, you can achieve effective absolute anonymity just by putting up enough practical barriers. So it is a serious problem.
And Superintendent, quick point, follow on that. As a prosecutor, understanding who's at the keyboard is really important for us, both to find out who may be committing a crime and to prevent someone who may be implicated but not committing the crime of being charged. So there's a conviction integrity piece to having information which is verifiable and traceable, and it cuts both ways, both perhaps exculpating individuals who may seem to have been drawn into a criminal network and who may have been their trust and friendship may have been betrayed by criminals who brought them in, and those who are actually committing crimes using a computer and sitting at that keyboard.
It sounds like if we're planning to issue some kind of regulatory scheme in the year ahead to deal with virtual currencies, but it sounds like if it turns out that technologies like tumblers are being used for no other purpose than to enhance anonymity and to thwart law enforcement, that may be something, as we do our regulatory work, we want to make sure the companies that we're reviewing aren't using those kinds of things. Would you both be in favor of that?
I mean, my experience with tumblers has been negative in terms of it being used for criminal conduct. I may have a more narrow view than is deserved, but I think, and I'm not a regulator, but I think a regulator could certainly want the ability to inspect why someone is using a tumbler, what the reason is for that, and any other devices that might be causing it to be more difficult to figure out who your customers are, who you're giving money to. So that could be something that can be inspected, inquired about, I would imagine.
Another reaction we got yesterday from some of the proponents of virtual currencies in our first day of hearings was they pointed to the recent arrests and said, see, it's under control. You don't have to have a particular worry about the criminal element here because we're seeing already law enforcement is catching up. Do either of you have a reaction to that?
I do. I think it's wrong because we're just getting virtual currency is a relatively recent phenomenon, and I certainly don't think, just let's be clear, cybercrime, identity theft is an international crime wave. I don't think the fact that we have made significant cases and arrests in this arena means that it's all under control. It's not. And so strong enforcement by the Southern District, strong cases by the DA's office does not prove that this isn't a problem. I think it proves the opposite. This is a problem. And when it's proven to be a problem, what is the regulatory framework that we should create in order to minimize the chance that that problem is permitted to fester and grow larger?
I would just add that we have both offices have brought some important successful cases. Those are fairly serious cases for a relatively nascent currency, and as a percentage of the legitimate commercial activity, that might be a disturbing percentage of big cases and money that's showing up in criminal conduct. That may be just the difficult road of entry for a currency, but I would also add, yes, there have been significant cases, but these cases like Silk Road and Liberty Reserve, there were hundreds of people engaged in criminal conduct dealing with these entities and dealing in virtual currencies. They have not all been arrested. Many of them did successfully, at least for now, keep themselves beyond jurisdiction. Many of them may be picking up and doing that somewhere else. So the fact that a bunch of cases have been brought doesn't mean that all the people who are engaged or even a large percentage of the people who might be engaged in criminal conduct regarding virtual currencies have been arrested and are being deterred. So,
nor are the
there's a lot to
penalties
do.
necessarily strict enough. I believe one of the defendants in your case in Liberty Reserve was an Arthur Badowski. He was indicted in our case in 2007, and sentenced in 2007 in connection with our Goldage case.
Right.
We now see him in Liberty Reserve.
Both of you have discussed the international footprint of many of these cases. Can you talk a little more about the kinds of hurdles that poses for investigations and how you overcome them, and any other further help you could use from regulators or others on those types of issues?
Yeah, sure. So a couple of the cases that I talked about, for instance, in Liberty Reserve, that bank relocated itself to Costa Rica to try and put itself beyond the jurisdiction of United States authorities. One defendant changed his citizenship. The bank ended up using numerous offshore shell companies all over the world. It makes it very difficult to investigate those cases, or makes it more difficult. You're working sometimes with jurisdictions that won't help you or are unable to help you. You don't have the ability necessarily to see what defendants are doing or look at the locations. And, you know, in Silk Road, similarly, there were administrators for the Silk Road website who were central to the operation of the website. We have ended up being able to arrest a number of those people, but they were operating all over the world, helping Silk Road to operate. So there are international, these are usually international cases. It requires a lot of cooperation with foreign law enforcement. I would think that would be true also, so you'd hope for, between regulators abroad, because there's a lot of information that where there are foreign regulators, they could probably help give it. But Silk Road operated through money exchangers, I said earlier, in Malaysia and Vietnam. It really relied on the lack of enforcement in other jurisdictions to try and preserve anonymity. So we were able to overcome those hurdles through a lot of good work, a lot of very intensive forensic computer work, among other things. But I think that you know, even many of the defendants we arrested are now facing extradition from other countries. They're not yet in our custody fully, and we'll see what happens with those and see how well extradition works. There are obviously some countries out there that will not extradite people for these crimes too, and so that's going to pose issues also. And you know, it's difficult to wait for people to travel when you know till they travel to a country where you can arrest them and then extradite them. So I think that's going to become more and more of a problem as cases are brought. People learn from what our officers are doing, and as they do in other areas, they try to put themselves in jurisdictions where they can't be extradited, can't be arrested. So, you know, regulators, I think, could do a lot talking to each other to help us with that. We're going to continue, I think, to work together and work with our foreign partners to try and overcome those problems.
To Rich's point, one of the principal defendants in the Western Express case that I talked about, more than 100,000 identities stolen and a significant international footprint. One of the principal defendants we had indicted, but were unable to, he lived in Eastern Europe, and he was operating the criminal enterprise out of Eastern Europe, and we were unable to get him. We had a notice in Interpol on his travel, and the only reason we were able to pick him up is because he took a vacation in Greece. And he decided to get a little sun, went to Greece, and he was apprehended there.
Got some heat, too.
And so that just speaks to this is a completely international crime. And I think if you speak with any experts on cyber fraud, they're going to tell you that the world of cybercrime is global, and many of the primary actors victimizing the United States are not on U.S. shores, and they are in distant places, which makes it very difficult for us to identify them, let alone prosecute them.
I want to open it up to my colleagues to ask a few questions, but I'll ask one more just out of personal interest. How do you deal with, when it comes to asset forfeiture in these cases, how do you deal with seizing the proceeds of a crime when the proceeds are often bitcoins or other virtual currency?
Well, as I sit here today, I represent the U.S. Attorney's Office. We're a large holder of Bitcoin right now, which maybe
how are you doing with that investment?
Gives people a different attitude toward the testimony, because we seized over $30 million in bitcoins in the Silk Road case, and we do that through civil forfeiture action, like you would against other assets and currency, and we treat it that way. So That has been seized from the Silk Road servers and computers and Mr. Ulbricht's personal computer, and we do that through civil forfeiture action. And I think it's an important thing to do. No one should keep the proceeds of crime, virtual or otherwise, and so we've seized it, and we hold those, and we also seize websites. We'll seize all the illegal websites that we could in Silk Road and Liberty Reserve. We did that, and we forfeit the businesses and whatever we can forfeit. So that's how we do. We seized it, treated it like regular currency.
Are there specific challenges, though, because it's digital and it's got a private key potentially with it? Do you have, I mean,
there are.
Might be getting too technical.
There are some challenges, but we were able to, overcome that with the de-encryption that was necessary, and so we are holders of bitcoins.
Are you going to exchange it for dollars?
I don't even want to address that. I don't want to affect the market in bitcoins in any way.
You're a big holder now. Any other questions?
Yeah, in addition to some of the entities that you both discussed today, are there other types of actors or entities in this space that you think will participate integrally in the criminal virtual currency cases?
I don't know how to really define the universe of actors, but there are people who are stealing, anyone who's around the globe in the market for stolen identities, and then there are people on the front end who are penetrating businesses and stealing identifications, and people on the ground in various countries helping to steal. So it's a very broad-based group of actors, and I'm not sure how to define them.
So I think that's right. What the district attorney's saying about people who also will commit crimes to bring money into the system. And within the virtual currency system, if you look at the cases, there are some third parties that are important to their functioning. So the currency exchangers, the ones that are located around the world, sometimes that are here, are important. So at some point, dollars get turned into bitcoins. And as we talk about, and this is really a regulator issue, but I think whatever anonymity may or should exist within the Bitcoin world, where Bitcoins may be buying products and being Bitcoins for other services or other Bitcoins, you have to enter and exit the system if you're going to go into any other currency. Dollars have to come in if we use dollars, and dollars have to come out. And so you have a chance to know what's going on at these exchangers where people are entering the system and coming out of the system. So it's almost like you can get ID'd going in and coming out, even if ID is not going on within it, which is a problem that the district attorney was also talking about. Other third parties are cash processors. There are third parties like Mr. Fiala used, where they arrange for an account to be set up at a bank, a regular bank, and then a person comes in with $1,000 of cash and puts that cash into the pre-designated account, which is the cash processor's account, and that cash processor is a company that will take that cash then, and there's really no identifying information, and then turn that into bitcoins for the person who will get bitcoins for it. But that's done in a way that obviously is not well regulated. And then there are the websites. There are individuals like Mr. Fiala, who, according to the allegations, was acting sort of as a one-person exchanger of currency. And then there are merchants who are also accepting bitcoins, and some of them are, as we've seen, doing that for illegal services. So I'm sure there are other players too. But those are some of the other types of entities that I think have been important in some of the cases.
It's interesting you mentioned it, because some of the testimony yesterday was that none of the exchanges of any significance in the world have come to the U.S. They're all overseas. And there was a lot of talk yesterday. The Bitcoin community, I think, would like to see regulators doing what they can to help encourage exchanges to be onshore here in the U.S. It would be good for innovation and good for business in the U.S. But it sounds like it would also be good for law enforcement in terms of weeding out the bad apples, and then we could have a double whammy, hopefully, where we're promoting more business and more innovation in New York, at the same time getting rid of the bad and separate the wheat. The good could thrive. So,
and I think there are some, I've heard there's some exchangers abroad who are at least complying with reporting obligations, or trying to. They might be, maybe there are some good examples out there for how that can work.
Yeah. Al Capone was convicted for not paying his taxes instead of bootlegging. And that raises an issue which I think, Mr. Zabel, you touched upon a moment ago. We yesterday were struggling with some of the panel guests in trying to figure out how we deal with minors, because they play such an integral role in such a systemic controlling function.
Minors, ER, not
I was
OR.
going to ask.
Yeah, not as in child pornography.
Minors
So,
as young as well.
right. And you mentioned a moment ago the possibility, and I had never really thought about this, but the securities implications of products being created now that could be based upon mining investments and how many things are mined. If we're unable, or at least to get our arms around those sorts of things, at least immediately, do you think that there are other avenues by which both regulation and prosecution could follow in order to get control of that? In other words, should we be thinking not just in terms of these anonymous miners, but some other activity that's implicated by them or depends upon them that we could tap into down the line, which would control them?
Well, if I understand the question correctly, what I was talking about was you can invest in mining companies like you invest in any other company, and it would be based on the value of the bitcoins they mined. Or you could, for instance, engage in like futures contracts, which also are tied to the value of bitcoins. And I think, so the concern that I foresee a little bit is with a very manipulable currency, which a young currency is, there can be a lot of fraud for quick hits in investment schemes and on currency contracts, and even if you're investing in companies that are based on the mining of that. Other ways to try and address that, I suppose would depend on whether you considered any of those types of investments or issues to be within the purview of the securities laws or within the commodities laws. I don't claim to have examined that issue enough to be fully expert in it, but I would think that if the market for bitcoins is going to mature, it's going to lead to these types of investments, and there's going to need to be oversight on it. And I think the regulators will have to decide, is this purely a currency money issue? Does it become a trading issue, either in terms of being a commodity or a security or some other kind of issue, which maybe it has to become that. But I do think that if the currency is succeeding, that's inevitable, right? That's the natural flow of capitalism and a capital market, is that you start having people invest in that way.
Yeah, we're trying to figure out where we appropriately enter the whole chain of regulation and where we should stop. So I know our friends from the SEC are here. One of the things that we're concerned about is the anonymity of miners. So along the example you gave, there could be disclosure requirements that if people want to buy and sell securities related to Bitcoin, you're going to have to identify yourself, you're going to have to identify your operation and comply with all those sorts of things. So I think we're trying to figure out whether on the, at certain rungs that give us concern, there are alternative ways of getting there, so that we might want to step back a little bit. But
right, there could be, you're right, clear regulations about if you're going to invest, in a way that's based on the value of bitcoins, whether it's investing in a company or investing in the currency itself, that certain required disclosures are going to be made by whoever's going to participate in those markets. I suppose it's a little outside my bailiwick, but it seems like it might be a logical thing to protect people against getting defrauded.
My understanding, the SEC has also already brought enforcement actions for securities violations in this area. So.
That was a case down in Texas.
Yep.
I think,
It's a Ponzi scheme.
Yeah, a Bitcoin Savings and Trust was, I think, the defendant in that case.
All right, well, we've already taken up more of your time than we should have. Thank you both for all the work you're doing in this area. Obviously, both of your offices are leaders in the cyber world and prosecutions, and it was a pleasure having you. Thank you for taking the time.
Thank you very much for having us.
Thanks for having us.
Yeah.